Okay. Hi, everyone. Thank you for this episode of Triumvir Unplugged. We are extremely ecstatic to have Mrinal Jain with us. Uh, before I head into, giving a more elaborate description of Mrinal and what he does, like I've tried to elaborate in all my, earlier sessions, that, the idea is to basically get, market leaders and understand, what led them to their journey and to where they are, right? And in that pursuit, we are extremely, happy to have Mrinal with us. Mrinal, thank you for joining us today. And yeah,
Absolutely my pleasure, Anubhab. Thank you so much for inviting me.
yeah. So, just a small introduction to Mrinal.
Sure.
He's the managing director at Secretariat, where he leads the firm's economic damages and valuations practice. He has an extensive practice of over 16 years. He has been a distinguished expert in the quantification of damages, claims, and losses, both in domestic as well as international arbitration matters, including investment treaty matters. He's been acknowledged and recognized by several leading arbitration lists, such as the Who's Who Legal and Thought Leadership Program, as an expert witness from 2021 to 2024. He graduated from the prestigious St. Stephen's College and Fordham Graduate School of Business. He began his career with the Big Four accounting firm in New York, and with that, he later then transitioned into this role in Secretariat. Just bare bones, how did you, interface your career with law? Like, was it thought out? Was it, providence? What was it? Like, how did you find yourself where you are today?
That's a very interesting question, Anubhab. And actually, I got exposure to the legal side of finance very early on. So while I was studying economics at Stevens, and I went to US, I was exposed to the legal side of disputes, right? I read about them. I read some case studies.
Right.
I even took some classes, some electives at my B school that were focused on the law side of it. And with my economics background and a finance background, I realized that corporate disputes and working as an expert is like a perfect combination of economics, law, and finance. It actually brings all three together.
Right.
And that combination is what I was looking for. So when I got campus placements when I was in New York, Manhattan, one of my focus areas was to be a part of a valuation and disputes team. So I was fortunate enough to get a role at Ernst& Young in New York. And when I commenced my career there, while that was primarily valuation for non-contentious purpose, I did get some exposure into valuation for contentious purposes as well. And that was the starting point. I realized that, um, there are some legal and factual cases, issues, and then you apply the background of economics and finance to quantify these complex claims. And that was the starting point. So I would say I was fortunate enough to get exposure early on, and that sort of built my interest. So when I came back to India after a few years of experience there, I was pretty sure that I want to pursue this as my career.
That's fascinating because, as practitioners or law students or let's say, even business students in India, like the fields that we are possibly segregated into are quite generalistic at times often. The practice is norm in law, at least, you would say, as you would obviously know, that, it's categorized into corporate practice or disputes practice or so on and so forth, right? Nowadays, what I see is that, I can see new, avenues coming out. People are not necessarily, adhering to, precedents such as, practice. They are going into law firm marketing, branding, so on and so forth, even after spending a substantial amount of time in law firms, right? And I think, you know, having law and economics are a social marriage in itself. Like, it's a combination which goes really, really well. I never had the chance to study economics as a law student because, shockingly, I studied BSc LLB, so I had to study chemistry. So,
Wow.
Yeah, so I had a completely different wing. Like, so I had to study subjects like toxicology, like, like from the criminal side of things, which was, so I never got, but I understand
Forensic side primarily, I'm
exactly,
sure.
exactly. But I understand how relevant, economics is, right? Even for law students who do not maybe want to, maneuver around the more traditional forms of practice, to go into, let's say, damages. So, to somebody who's maybe listening to us from as a fourth year or a fifth year or a third year law student who's looking and maybe is absolutely disillusioned by what is to be done going forward, what does a career as a valuation expert entail, like, from that perspective?
Sure. Again, I think that's an excellent question because
Yeah.
when you're dealing with valuation expertise or when you're dealing with damages expertise, you need to understand very clearly the fundamental principles of damages, which actually emanate from legal principles, right? Are we talking about reliance damages, wasted cost,
Yeah.
or are we talking
Yeah.
about expectation damages, loss of future profits, or are we talking about, assessment of fair market value in a joint venture or shareholder dispute?
Right.
All of these have their roots in the legal principles, which we don't understand because we're economists or we're valuation experts.
Yeah.
I think somewhere as a valuation expert, whilst it's assumed that you would have an understanding of valuation principle, the scientific approach, the art of valuation principles, you also need to understand how to bridge that gap. And I think that's what this job entails. As a damages expert, we need to clearly understand what are the instructions from the councils or the arbitrators, whoever is appointing us,
Us.
and then link those principles to the valuation principles or the damages principles, and then apply those sciences, apply the facts of the case, apply the market principles to arrive at a value of a claim. I think that's what this expertise is all about. I think it's very difficult to segregate and put a valuation expert in a silo which is independent of legal principles or counsels or arbitrators. That would be wrong. I think all of this works in a tandem where we are instructed by counsels such as yours, Anubhav,
Correct.
and
Correct.
we need to be aligned with those legal principles, right? If in your case you're pleading a loss of profit under expectation damages, I need to then apply the principle of expectation damages
Exactly.
to build a but-for scenario or a counterfactual scenario, an actual scenario, and then calculate that. So I think application of valuation principles have to be aligned with the legal principle, and that's what the valuation expertise is helpful, because if you understand the fundamental principles of economics, finance, you can apply them and you can align yourself with those legal principles. That's one part of the expert. And of course, there's cross examinations, being in the hot seat,
I
being
will
cross
come to
examined
that.
by
I
the
will
other
come to that.
side.
Because that's a whole new
In my
discussion
view, it's a whole
altogether.
new discussion. That's true.
Altogether. So that's fascinating because because as a valuation expert, you also build credibility because the name of the
Right.
game is credibility, and so there is lesser and lesser chance from deviating if from the legal principles as such as well, right? Because your credibility is what sets you in the market, and that's how you go forward. So yeah, no, but that's exactly what I was looking for, So when we approach a case at hand, right? When we're looking from either the claimant side or the respondent side, we are trying to, come to the most realistic, and the most pragmatic approach and the solution to be taken to reach a solution for the parties at hand, right? However, what I have seen from a practice or a counsel perspective is that when we represent clients from the global north and the global south, there's a huge difference in approach towards litigation strategies as well. Is that the case that you feel, in terms of approachability to valuation experts in relation to disputes in the global north and the global south?
So just to ensure that I understand your question correctly, are you talking about differences in the
In approach,
arbitration
yeah, difference in approach maybe.
globally versus
Yeah, yeah, exactly. Like in India, maybe like are they more permeable to that, the act of, appointing more valuation experts, so on and so forth.
I would say if you would have asked me this question 10 years back, I would have given you a bit of negative response.
Correct.
Um, Things have changed
Yes.
um, very, very positively over the last 10 years. We had a couple of experts working in India a decade back, and I could really count them on fingers because there was no practice of appointing independent experts. And the reason is because I think um, the domestic arbitration practice, and especially the arbitrators or retired Supreme Court judges,
Right.
did not feel the need
Mm.
for appointing
Exactly.
an independent expert. Things have changed drastically now,
Yeah.
and for good. Even in India, not just the international arbitrations or the institutional arbitrations, where, of course, it's a very common factor to have an independent expert. Even in domestic ad hoc arbitration, I've seen arbitrators having an open mindset towards independent expert. They've realized that if the subject matter of contention is technical, it requires certain damages skills or
Right.
valuation skills, they would be very happy to opine on or at least look or consider an independent expert report. I think what is important is for the experts to ensure that whilst they could be appointed by either of the parties, they need to put their duty towards the tribunal at the top. Their role, they need to understand that is towards the tribunal to assist the tribunal in convincing the tribunal that their assessment of damage is reasonable, credible, and reliable, and it provides a more realistic view of where the claim could fall, rather than being considered as a party appointed hired gun, which does not solve the purpose of having an independent expert in the first place. So I think we are at a stage where the arbitrators and the judges, both, I'm talking about both litigation and arbitration, not so much in litigation. Arbitration, definitely the scenario has changed drastically. So we are in a position where they're very openly welcoming independent experts. At the same
Yeah.
time, I think it's important that experts should ensure that they realize what's their ultimate duty and therefore play a fair game over there.
You're truly correct on this because it's my personal observation that an expert can never be party appointed. The ambition of an expert is always to pursue assist the tribunal, and
Right.
if it's either appointed by the tribunal, it's either appointed by the parties to assist the tribunal as such.
Right.
So I think that's the end goal that one should be looking at. I mean, from your vast experience in working on these cases, could you maybe enlighten us with the particular circumstances which was seemingly complicated and trying to basically arrive at a number? What for such complications we face with amidst parties, tribunals, to do your work as such?
A very interesting question. There could be complications at various levels,
Correct.
Anubhav. I think the first and foremost complication in whether domestic or international arbitration, I think I would now give a response which is very common to both scenarios.
Right.
About 60% of my work today is actually international arbitration that's
Right.
got nothing to do with India.
Correct.
So none of the parties are Indian. But even in domestic matters, I think the first complication emanates from difference in instructions from the respective councils to the experts. The two side experts, the two experts representing the two parties, need to reduce their opinions where they disagree, right? And that is possible only once the instructions are common. But often we see that the instructions from the councils would be very different. The assumptions would be very different. If, for example, it's a case of a continuous breach in a commercial dispute, one council would insist on instructing on a particular date of breach, and the other council would have a very different view on that particular date of breach. And the two experts therefore sit on very extreme ends in terms of the value of the claim. This doesn't help anyone. It doesn't help the tribunal, doesn't help the parties, doesn't help the councils. I think, in my view, the first sort of rule or the first sort of complication would be these differing instructions, and therefore councils can play a very vital role by ensuring that they give the same instructions to the two experts. That would really help everybody in the dispute resolution process. The second approach which I feel the experts should play in terms of complications is ensure that you maintain your unbiased and scientific approach throughout the
Exactly.
process. Constantly, there'll be
Yeah.
pressures from the clients, from the councils. Look, councils are solicitors, at the end of the day, and both clients and councils, they may try and put you in a scenario where you're not comfortable with certain positions. I think it's important when I say that an expert should be independent, that doesn't mean that I'm not flexible enough to hear my client's positions or counsel's position.
Yeah.
We need to take into account instructions from the councils, the facts and the positions that the clients are stating, but still retain our unbiased scientific approach in calculating damages. I think that's the essence of presenting a very reasonable view to the tribunal. And that really would help in simplifying those complications. So, in my view, the second challenge would be how delicately you balance the pressures from the clients and councils, understand their factual positions, the instructions,
Right.
yet retain your unbiased approach towards this. And third complication I think would be to ensure that often we've seen there's a trend, of course, of having joint expert reports, of being in a hot tub.
Yeah.
I think it's very essential that you don't make it personal, right? It's not about you versus me, the two experts. It's simply about narrowing down the areas of differences between the two experts.
Yeah.
I
But
think that's.
that's less often the case that we see. We are,
I agree.
yeah.
I agree.
But
So,
yeah.
sorry, go ahead.
No, but I think what you're saying is that like just making the systems and adhering to the legal principles that are there makes the matter even more easier, right? Like it's
Right.
less challengeable. They're less likely to raise any questions or exclamation marks on that, right?
Correct. That
Yeah,
is true.
yeah.
That's
And you were
precisely what.
saying something. I was just trying to.
No, I was just trying to conclude that that the third area of challenge arises when the two experts are extremely strong-headed in their opinion, with a strong reluctance to arrive at a conclusion that could assist the tribunal. I think that doesn't help. So it's very important that the experts have an open mindset when they're dealing with difference in opinions. They need to present alternate views to the tribunal and let the
Correct.
tribunal decide. It's not about winning a battle over the other. It's simply about identifying those areas of differences and then presenting to the tribunal that these are the alternate results if the assumption is A versus B.
Right.
And finally, I think one more area where there are challenges that I found and can be overcome is when the tribunals get involved. If the tribunal doesn't get involved in either the cross examination or hot tubbing, I think again the result or the outcome of that cross examination hot tub is again with extreme ends. The more tribunal gets involved in direct questioning with the experts,
That's
or if the hot tub is administered by the tribunal directly, I think it makes the entire process more fruitful. So
yeah.
these are some of the challenges that I've faced, and I think are some of the solutions one can work with.
No, that makes sense. See, at any given point, it might be difficult to maneuver these challenges, but then the thing is that the idea is that we do have the principles in place, we do have the arbitrators in place to mind and monitor these circumstances for us to go. But I personally had something to ask you, and I'll just be moving the topic a bit, like so from a council perspective, when we deal with, let's say, investment treaty arbitrations, right?
Right.
uh, we are either somewhat categorized as states or investors, right? And that's a trend we've not only seen with councils, we've also seen, let's say, with arbitrators as well, right? And this often leads to maybe, segregating a certain practitioner as, from one side itself, that, they can't really provide the perspective from another. As an expert who've also dealt with investment treaty claims, do you think that is something that you faced with? Because this is something that came to my mind, when we were just deliberating on the earlier issue.
Oh, I love this question. And I've been into both positions,
Yeah,
Anubhav. I've represented the investors, I've also represented the states.
yeah,
As a damages expert, um, I would say it I don't think you can categorize or label an expert being only the state expert or only the investor expert, right?
Correct.
Because ultimately our expertise lies in the principles of valuation.
Right.
How do we calculate the compensation, right?
Right.
So, what's important to understand is your role as an expert changes, right?
Correct.
When you're representing the investor, your primary role is to calculate the fair market value of the investment,
Yeah.
but for expropriation, or if it's a wrongful expropriation case, or if there's any other breach
Correct.
that you're referring.
Right.
When you're representing the state, your role as an expert is more how to rebut that claim,
Yeah.
to focus more on causation, right? That um, erosion of the investment value or the expropriation of the investment that happened. That erosion in the fair market value of investment could happen due to various factors other than the breach or expropriation, right? There
Mhm.
could be several market factors,
Mhm.
economy factors, which are unrelated to the state or the policy actions.
Mhm.
I think the role of expert on the state side then becomes more strategic in terms of understanding the
Mhm.
causation, the causal link, the
Mhm.
principles underlying what's the investment
Correct.
and how it got eroded, and whether the factors that resulted in the erosion of fair market value of investments are directly related to the state or policy actions. So the role of expert changes on both sides, but I've seen experts, including me, representing both positions in the past.
No, that's very interesting because, we have seen particularly, for example, there are arbitrators, who are classified and appointed time and again, let's say by states,
By
right?
states, that's true.
Or time and again by investors. And over a
Right,
period of time, they seem to, let's say, gather a reputation. Okay. And then the other side is wary of such an appointment, right?
right.
And and I think that's counterproductive in the case of an expert itself because an expert's mandate similar to an arbitrator's mandate, but it's glad to see that it's not moved to an expert. This such a classification has not yet moved to
Thankfully, not yet.
not
Thankfully, not
not
yet.
yet. Because if you look at it, an arbitrator's role is seemingly the same. They have to evaluate the case from a specific perspective. But we have ourselves faced such situations where we propose an arbitrator and so on and so forth. We face serious oppositions from clients saying that they are either from the state or from the investor. We are very very wary of appointing. Uh, Although I've seen investors appoint states pro state or state specific
Correct.
arbitrators, but I've not seen it the other way in my limited experience as of yet. So yeah. But I just
No,
wanted,
I agree with you.
yeah,
I agree with you. In fact, one thing that works in the benefit of experts is if I've done more and more investor side cases, in fact, I'll be more equipped to rebut it. I'll have a lot of experience. If I know how this is exactly calculated, when I get represented by the state, I will then be in a much better position to rebut it because I know what are the contours that are being used to build that investment
right,
analysis.
right.
So at least fortunately, at the expert side, still I haven't seen that kind of categorization or silos being built.
That's good to know. I mean, I'm ecstatic because to speak to you because my myself for my master's, my thesis was moral damages investment treaty arbitration. So
Wow.
so I delved into like length and breadth of it, and then at the end of the day, my supervisor said that as a civil lawyer, I don't think there should be anything called moral damages. So I was quite confused, but I'll get to that later. It
Sure.
was it was it was quite a long time back, but then I just want to understand that anybody looking at you from a layman's perspective, right?
Sure.
Okay, and let's say you're before a tribunal evaluating a shareholders dispute as such, right? As a tribunal appointed expert, right? What and how and what principles you're looking at in terms of loss of value or loss of profits and so on and so forth, right? How are you approaching a given case of a share like shareholder dispute? What are the principles that are basically utilized in these cases at hand? Okay, because it might be important to get down to the basics to understand where these principles that we talk of are coming from as such, right?
Right. I know, absolutely.
Yeah,
A large part of my portfolio actually involves shareholder and
right,
joint venture disputes.
right,
And these are very complex cases. This could actually be very contentious and complex, where
Exactly.
you could be representing the promoters, you could be representing the shareholders. I think, okay, let me start with first understanding, and these are some of the questions that I ask councils when they approach me for these
Yeah.
kind of disputes.
Yeah.
My first question is, what's the breach? What is the cause of
Correct.
that dispute? Are we talking about simple exit disputes, that there was an exit clause, there was a put option, and the financial investor or the shareholder wanted to make an exit, but the promoter failed to provide that exit, and therefore there's a dispute? Or are we dealing with cases of mismanagement,
Right.
operational issues? Because those tend to become more complex. In cases of exit disputes, I still feel the heads of claims and the damages are more simpler, right? Because you would either start with specific performance of that particular exit clause or that put option clause, because your client wants to make an exit at a predetermined internal rate of return stipulated in the SHA. Or in alternate, you ask for your reliance damages, which is the second head of claim, where you ask for the entire investment amount to be
Right.
returned back
Right.
with some reasonable return on investment, right?
Correct.
But when it's a case of mismanagement, or it's a case of operational issues, where the disputes are so entangled, the disagreement is so entangled that it's affecting the day-to-day operations of the business, there the issues can become very, very complex, right? The shareholder might not want to exit. The shareholder might want to continue, right? In that case, you're not looking for a reliance damage, which is your sort of, entire investment plus return. What you're really looking for is diminution in the fair market value of your
Yeah.
investment,
Yeah. Yeah.
right?
Yeah.
And I've seen that head of claim very common, right?
Correct.
Basically, what the councils would legally plead that because of the mismanagement or alleged wrongful actions of the other shareholder, the fair market value of the investment of your client, basically the fair market value of your client's equity investment in the company, has diminished.
Correct.
So what you're trying to claim there is that, well, your client would still be a shareholder in the company.
Yeah.
What I want is that decline or diminution in the fair market value of the investment
Yeah.
that client has suffered.
Right.
That becomes challenging, right? So
Right.
there the questions is, when did the mismanagement start? When did the operational issue start? When did the breach start? And these are more legal questions, but these are the kind of questions that we would ask you, right? Because it has a direct implication of how we
Correct.
calculate those kinds of
Correct.
claims.
Correct.
So, you would not want to understand what is the start date of the breach. Is the breach still being continued? Is the breach corrected? Is the mismanagement taken care of? Sometimes it's not mismanagement, it's simply lack of management, right? One of the shareholders doesn't take any interest,
Yeah.
which we see very commonly in private equity investments. So, in
Absolutely.
those kind of scenarios, you want to figure out, what's the end date? Is it corrected? Is it not corrected? So, is it a continuous breach that is happening? When do you want to calculate the fair market value of the company, the fair market value of investment? Sometimes I've seen councils not only make the shareholder as one of the claimants, but also the company. So you have shareholder as the claimant, and then you also have the company as the claimant. Now, the company can claim loss of profits. The shareholder would claim diminution in the fair market value of its investment. So we've seen these complex heads of claims, playing their
Yeah.
roles depending on what's the breach, whether it's mismanagement, it's just the exit clause. When it's just a simply an exit dispute, then the question comes, you need to simply calculate the fair market value of your client's equity interest in the company as of a given date.
Correct.
Then the question comes, are there issues regarding exit? Was the exit possible? Was IPO possible? Not possible? What are the other exit mechanisms that would have been possible but could not happen because of the wrongful actions of the counterparty? So, in my view, there are these several factors that impact various heads of claims in a shareholder dispute.
No, that's fascinating because so like I said, we do one of our areas of work also is private equity and venture capital, right? And in one of the drafts, we in fact saw what would entail a continuing dispute breach. And I think councils are getting more and more aware of, these circumstances. In fact, there was a notice of breach clause which said that in the event that a notice of breach, when intimated, is not returned within the next 5 days or challenged within the next 5 days, the breach should be constituted from the date such notice has been received.
Wow.
Okay. And I've seen it in one investor, private equity investor, from UK sent like their draft. So I was quite fascinated by it because I do a bit of disputes as well, so I'm aware of both these perspectives. So and that and what you said puts all of these things into whole perspective. And but do you think that corporate lawyers can help valuers in the process of maybe drafting agreements in a way which maybe makes your job easier?
Absolutely. It begins with there. I mean, if the corporate lawyers have made a very watertight contract,
Yeah,
have drafted or stipulated the dispute resolution clause loud and clear, which doesn't leave any ambiguity or room for contention, I think that would make our job very, very easy. I'll just give you a small example.
yeah, yeah.
Uh, Valuation standard, right? We say
Correct.
fair market value.
Value.
It's one of the valuation standards that's being used often in commercial disputes, joint venture
Absolutely.
shareholder
Yeah.
disputes. Now, I still see several contracts, not just in India, across the world, where fair market value is not used as a valuation standard. And that sort of puts the experts in a difficult position, counsels in a difficult position. Look, fair market value as a standard brings sanity to the entire process, right?
Correct.
Because
Yeah.
you're dealing with a hypothetical buyer, seller, and the overall objective is to ensure that you consider a market participant view. You don't consider any claimant or respondent specific synergies in your
Yeah.
valuation.
Yeah.
So I've often seen contracts which are more watertight. They will clearly define that in case of a dispute, valuation to be carried out on a fair market value basis by
Yeah.
an independent firm,
Mhm.
etc. So just by introducing that one simple sentence, it brings so much of sanity to the entire dispute resolution process. But that's just one example. I'm saying there
Exactly.
are so many such watertight clauses that one can introduce in these contracts so that if and when the dispute arises, it's a more amicable resolution, or at least there's a method to the madness.
If I can pick your brain more, like you mentioned about this, that the valuation will be done in accordance with the discounted cash flow, or the method that you mentioned. But if I and like I mentioned earlier, that we had also seen, let's say, the breach commencement of breach date clauses. I mean, can you maybe just picking your brain, think of any other circumstances which really makes the process any blemish absolutely blemish free, and makes your work way more legitimate, way more unquestionable as such?
Sure. I mean, so let me first try and take a step back and differentiate. So, discounted cash flow method is a valuation method. It's very different from valuation standard.
Correct.
So, when I say fair market
Exactly.
value standard,
Mhm.
it's not a methodology.
Correct.
It's a standard which allows experts, tribunals, and councils
Right.
to interpret valuation within the realm of a market participant scenario.
Right.
So the fair market value standard lays down the principles that you're not going to
Yeah.
consider any claimants, respondent specific synergies, etc. Now, when we talk about valuation methods, there could be various methods, a discounted cash flow method, as you said, or multiples approach, market multiples, or a cost approach, right?
Yeah.
I don't think limiting having a clause that limits experts to use a particular approach over another would help. Unless, at the time of drafting the contract, the parties are very clear that if they want to have an exit, that exit would be some X times of a profit measure. So
Correct.
I've seen some of the contracts which clearly stipulate that the exit clause would
10x
happen
or
at 10x of
yeah.
EBITDA, right?
Yeah. Yeah.
In those scenarios, you don't even need an expert, right? Because
Yeah.
it's very clearly, unless there's a dispute or contention
Correct.
over that
That
in
clause.
itself.
Yeah.
So when I say watertight clauses, these are the valuation or exit clauses that need to be very watertight, right? I've seen in some of the contracts they talk about a predetermined IRR,
Yeah.
internal
Yeah.
rate of return,
Yeah. Yeah.
right?
Yeah.
This one arbitration I was involved in, which it said that within the stipulated period of time,
Yeah.
there's an option that the investor has to make an exit at a 25% predetermined
Oh,
IRR. A 25% IRR, you know what that means? Your money is going to double in less than 4 years.
correct.
Um, that is an that is really when you have these kind of clauses, without having any additional caveats around it, right?
Correct.
Whether it is linked to your profitability, whether it's linked to your revenues, there should be some
Some
well-defined mechanism of those exit
mechanism.
clauses.
Yeah. Otherwise, it just leads to more confusion rather than helping. Yeah.
Exactly, exactly.
Unfortunately. Yeah. No, but yeah. So I mean, now that we've covered a bit of, understanding what the work entails and how we can maneuver these processes and what these principles, underlying principles are as such, I think one of the more important facets of a valuer is appearing before tribunals as an expert, right? And expert witness cross examinations don't often go as per plan. Uh, uh, so what does this part of your job entail as such, right? Because you might also be dealing with people who are absolutely not aware of the semantics, the technicalities of what your report entails, right?
Right.
So yeah.
Okay. In my view, cross-examination is as important or even more important than
Correct.
uh, writing the expert report. And the reason is because this is an opportunity for each expert to convince the tribunal, to assist the tribunal, to let them know that the work that is stipulated in the report is done by you. You are the mind behind that work. Because oftentimes we've seen the expert is completely clueless in terms of what's written in the report.
Yeah,
Because it's a junior team that drafts the report and you have no idea what's written in the appendices of the report. That's extremely damaging to the credibility. Um,
absolutely.
I think the sole objective of cross examination, from the expert point of view, is to give short, crisp answers to the cross examining counsel to let them know what is your view on each of the assumption. Your report could be subject to certain counsel instructions, and often we've seen the other side counsels attack you in
Yeah,
terms of
yeah,
those legal instructions, right?
yeah,
It is a legal instruction. Don't question me, question the counsels.
yeah,
The put across those points in your opening closing submissions. It's not for me to address, it's for the counsels to address. Secondly, a lot of times I have seen opposing counsels asking questions related to facts, asking questions related to legal positions like causation, etc., or they're asking questions that has nothing to do with what we've written in the report. I think that simply helps experts like us
yeah,
because we can clearly show to the tribunal that what is being asked to me has nothing to do with what I've written in the report.
yeah,
If it's a question of fact, ask the fact witnesses. If it's a question of law, ask or address it to the counsels, right?
yeah,
You ask me on my expertise. And that's where it's very important. And that's where I said, cross examination and report writing both are equally important
yeah,
because
yeah,
when you write the report, you need to be very crisp and exactly define what's your area of expertise, what are your instructions, what are your assumptions, what are the facts, and that your conclusions are within your area of expertise. So allow the other side counsel to penetrate you further, to question you further on that area of expertise. If the counsel is deviating and asking questions, we should be very direct to them that these are not meant for us. And I think that's what I feel is very very difficult role of an expert witness because you need to very sometimes you get carried away, you get emotional, you get personal, and you want to step on the boundary where you start answering questions which are more legal, right? So I'll give you an example. There are
correct.
some principles like causation mitigation,
Yeah,
which are a combination of legal and economic financial
right,
principles, right?
right.
While causation is completely legal, there are economic and financial consequences of the valuation analysis that you're doing, right? Whether the claim that you're calculating can be directly attributed to the breach,
Correct.
right? Sometimes there's a financial angle to it. So you should be able, as an expert, you should be able to explain that link, the causal link, from an economic perspective to the tribunal.
Yeah.
But if that discussion goes more towards on the legal side, I would stay away. So that's just an example. These are some of the gray areas where, counsels can
No,
question you
but this is
more.
interesting because I intended to, pick your brain on this. Like, how would you assess whether a certain party has taken adequate steps so as to say to minimize their damages? Like, what would be your, standpoint on that?
So principle of mitigation, it of course it's very relevant, and when we as experts discuss these claims in valuation analysis with counsels, we often have discussions and questions to understand first whether mitigation was at all possible, because in certain circumstances, mitigation is just not possible, right?
Hmm.
Second, if mitigation was possible,
Hmm.
did the client make reasonable efforts to mitigate its losses?
Hmm.
As an expert, while I don't have to go into the factual and legal
Yeah,
analysis of it, but it's important for me to understand, did the client make some reasonable efforts? What are the evidences for that? Have I looked at those emails or correspondences that helps me understand, yes, client did make an effort to mitigate its losses. Third, if it was successful in mitigating its losses, then my role becomes important because I need to then understand what is the mitigated actual position. So when I'm calculating damages, I need to then consider the mitigated actual position and not the actual position in
position as
calculating
such.
losses.
Yeah,
Exactly.
yeah, yeah. That makes sense. I mean, coming back to your role as a witness, and of course, we've all seen that we do have directives to, let's say, rattle the witness expert, or move them from your comfort spot and all of that. And I understand that, to keep your calm is the name of the game, and you're as an expert witness, the job is per se to, just stick to your principles, stick to your report, and answering the questions based on that. But there are times I've seen, you know, witnesses going astray, and going into uncharted territories where they should not be going, and that in fact becomes a problem, right? So, as an expert witness who has appeared before several tribunals, do you think that the insistence or intervention of the tribunals are mandated at this point of time, and how to what extent, if at all?
I would say it is any intervention from tribunal is actually helpful. I
Okay.
would like to see it that way. And the reason is very simple. If tribunal is asking me questions directly,
Correct.
that means they are trying to understand what I've written in the
Yeah.
report.
Yeah.
I would rather be in a position
Yeah.
where I have a direct interaction with them to explain
Yeah.
what I've written than be in a position where they have failed to understand what I've said in the report.
Report.
That
Yeah.
doesn't help
Yeah.
anyone.
Yeah.
So I mean, I'm not sure whether it should be mandated or not. I just feel more comfortable and I'm more happy
Happy.
when I see tribunal taking interest in my report. Tribunal is asking me questions and they're engaging with me. I consider that as a success to my work.
So, from my personal experience on dealing with expert witnesses as a counsel, from a counsel's perspective, I think it's completely different. It's you should be able to ask questions to an expert witness, which he is not able to explain and go on an explanatory note. Because the moment you give them that, right? That's their expertise, and they will try to justify their report to the best of their abilities. And you eat out on your time to ask questions, and you're done.
Correct.
And
I agree with that.
and any good expert does just that. I
Right.
once had the opportunity to cross-examine, which is very rare in international arbitrations, a handwriting expert. Okay,
Oh, wow.
okay,
Okay.
which is rare. I've never done more than two in my entire career, and these processes are very very technical, right? There are various scientific processes like the sunlight process, the impression process. What copy of checks were given to you? Where was it the originals? And from my forensic background, I was trying to approach that, but I was quite young in my profession at that point of time, and asking questions which allow the experts to speak is the worst thing that you can do to your case as a counsel. It's my opinion. So
I've seen often councils, and you're absolutely right. I think questions from the council should be crisp yes and
yes,
no,
yeah,
because it's not a battle. You don't have to prove during the cross examination
yeah.
that the credibility is gone, or this expert makes no sense. I don't think that should be the objective. I think the council should have a very clear view in terms of what are the key points that they want from the expert as a yes no, and then stick to that script. having open-ended questions from experts is devastating, right? The experts can really take you right because
Yeah,
that gives them an opportunity to explain to the tribunal. Look, for me, it's not important what questions you're asking me as a
right,
opposing counsel. For me, what's important is that I'm convincing those three individuals there in terms of what I've written in the report.
right.
That's my objective.
Yeah,
You can be harsh to me, you can be rude to me, you can ask me any question.
yeah,
That's perfectly fine. My objective is to convince them that what I've done is
yeah.
reasonable and reliable. That's all.
And get an order. Yeah, yeah.
Exactly.
Uh, now, now we've dealt a lot on, like, what economic damages stand for. But, like, I'll come to something of my personal interest, like I just pointed out, like,
Mm.
earlier. Um, like investment treaty arbitrations as such over the last decade or more than that has seen a certain sudden rise in moral damages into the foray of, as a part of, claims and so on and so forth, right? I mean, the jury is out. A lot of people do accommodate these things, you know. But the whole question is, how do you even scientifically quantify, measure and so on and so forth in relation to that, right? And there is a lot of academic study that goes on between that. What would your take be, and have you dealt with any of these situations dealing with moral damages? Because
Uh,
post Desert Line, I think Desert Line was their judgment in
correct.
2008, and post that, I think there have been a 90% raise as opposed to there was zero from 1980 to 2008, and since then there has been a
Correct.
sea change in the approach, and parties are more and more claiming moral damages. Investors are claiming moral damages. What's your take on that?
Um, uh, Unfortunately, I haven't dealt with moral
Mm,
damages ever.
right.
So I would not have a very strong view on this. Although I feel that at the end of the day, everything boils down to what is the real or actual cash flow loss that the investor has suffered, right? I think the question that you're trying to understand from an economic perspective, financial perspective, is what's the real loss that the investor has suffered? What was the investment worth? And what is that loss that should be compensated to bring the investor back to whole position, right? That's the principle that you're trying to understand. I feel that any sort of head of claim, and again, I'm not a lawyer, so how you categorize that as moral or expectation or reliance, at the end of the day, should try and compensate that investor for that real cash flow loss. So when understand from counsel, and I'm sorry, I don't have a perfect answer for this
No,
because I've
that's
not dealt.
absolutely fine. I just wanted to, for purely academic reasons. Okay, we are right
So
there.
the question when I'm dealing with investment perspective in a treaty arbitration, the question is what that investment would have been worth at the date of expropriation or as of today, and that's what should be compensated. Now, whether there's a moral element to it, there is a goodwill element to it, there's a reputational element to it. To large extent, all of that should get captured in the cash flow analysis, and if that is not getting captured, then in my view, definitely there should be an incremental approach to quantify these moral damages. I haven't dealt with anyone yet. So once I do with that, I'm more than happy to have another discussion.
No, I would love to, because I mean, the challenge that lies is that, of course, what you're saying is absolutely correct. It's seemingly impossible to quantify. So, the circumstances that are pulled out to be quantified as moral damages as such are, for example, like an investor's, office being locked out, okay,
Yeah,
and the head of, and their chairman or whatever tortured by the state police, or so on and so forth, right? Such a situation, or humiliated in public, or
correct.
they go under any trauma, or mental restraint. So there has been a rise in that. So the argument that I have seen is that, why don't you make it akin to human rights damages, where,
Yeah,
okay, but then there are arguments pro and against that. But this takes us back to the I think the case before the Permanent Court of International Justice, where restitution was discussed, and most of the scholars discussed that whatever it was, it should be restituted to back to that level, right?
make it whole. Correct. That's
Make
true.
it
That is true.
make it whole. But strangely, uh, in terms of international law, what you are saying is absolutely rational and makes sense, but the academics and the legislations have not helped.
Right.
The state, because the International Court of Justice in itself has identified that, there are damages uh, which might not be quantifiable and they should be given. And that has been subsequently captured in the Articles of State Responsibility, as we see in written letters. So and that's just one sentence, and there's nothing more to that. So that's what.
You're absolutely right. I've seen different councils using different approaches when it comes to treaty
Yeah,
arbitrations, right? So
yeah,
um, we discussed the fair market value
correct.
approach, right? That's one
Yeah,
of the valuation standards
yeah,
that's very commonly used
yeah,
in treaty cases. I've
yeah,
also seen councils use investment value standard, which is very different from fair
yeah,
market value
yeah,
standard.
yeah,
And I've seen councils using the same restitution principle, and when they're pleading for unlawful expropriations, right? Then they would argue that it's the investment value standard where you do need to consider investor specific synergies. You can't apply a fair market value standard because you need to make the investor whole. So even if that investment value
yeah,
included some investment specific synergies, you need to include them
yeah,
and make the investor whole.
yeah,
So those are some of the extreme positions, right,
correct,
taken by the councils where they feel it's an unlawful expropriation.
correct,
We got to follow, and they would
correct,
instruct the experts accordingly that
correct,
follow the investment value standard
right,
and do that valuation accordingly.
right,
Now, again, principally, there's an in if you're following or if you're pleading the unlawful expropriation, you can have an option to choose the date of valuation to be the date of expropriation or a current date, wherever the compensation is higher, right? And you have enough cases to support Yukos versus Russia, right? Where the difference in the compensation as of date of expropriation versus as of date of award was significantly or
extremely high.
material difference.
Yeah, yeah, yeah,
So, I mean, I've seen some very different positions taken by the councils when it comes to treaty arbitrations. And as I said, at the end of the day, experts need to be aligned with the legally pleaded positions,
yeah.
and we need to work within that realm. So yeah, it differs from council to council.
No, thank you for even speaking on this. I know this is a completely elusive topic of law that they, so to say. But just leaving thoughts, okay. And I wanted to, my last possibly, question to you would be that the huge discussion regarding reforms in investor-state arbitration. Okay, councils, arbitrators, stakeholders alike from a economic valuer's perspective, what should be, you know, you know, what should be the discussions in relation to reforms be around in investment treaty arbitration? Because I think this is the first time where we see that there is a significant discussion and dialogue that's been happening for a substantial period of time. So yeah, from maybe a valuer's perspective, what do you think is your take on that?
Sure. Again, very interesting question and something really interesting to end the conversation.
Yeah,
And I think we all look forward to implementing international best practices, right?
correct.
Whether it's legal principles or economic financial principles, we all, it's somewhere at the back of the mind, have an objective to follow international best practices when it comes to assessment of compensation, use globally accepted approaches and methodologies, and which is what we have been doing, which is what we're making an attempt to do to make our entire process more competitive, more in aligned with the best practices that's followed in some of the developed countries. But
Uniformity.
uniformity, but at the same time, we need to understand and we need to be cognizant of the fact that Indian economy is very unique and different
Absolutely.
from the others. So whether it's an Indian investor against a foreign state or a foreign investor against the Indian state, whichever side you're representing, you need to be cognizant of the macroeconomic, microeconomic factors, the regulatory environment, the industrial environment. Everything differs, right?
Yeah,
And you need to take them into account before you finalize any compensation. So I think just blindly following an international approach would not help. Similarly, just blindly following something that has been done domestically would not help. It has to be a very scientifically thought mixed approach where you apply the principles that are best practices, but be cognizant of the Indian economics and the market scenarios. That's what my take is on the future of the arbitration name.
So it makes sense also because when the whole gamut of investment treaty arbitrations on investors, or when we saw the rise in investment treaties as such, the semantics of the dynamic in the economic situation of the world was much different to what it is right now. And absolutely makes sense. And I think more than uniformity, I think this all stakeholders from experts, from councils to arbitrators alike, need to very categorically uniformize in this system, to take it forward. Thank you, Mrinal. I had a fascinating conversation with you, however short it was. But thank you so much for your time. Really appreciate it. It was really insightful. And I think if I was, 15 years back, a law student looking at this, I would have different perspectives on a career other than, what traditionally we are offered. And that's the ambition, and that's what we were trying to do. And thank you so much for your time, and we really, really appreciate it.
Absolutely my pleasure. Thank you so much.
Thank you. Thank you. Thank you, Manal.